Good morning, this is your Kelso Report for Wednesday, August 1st, and I'm your host, Clark Kelso. We begin today with a remedies case out of the Ninth Circuit in Lee versus West Coast Life Insurance. The Ninth Circuit heard a case involving a dispute over the proceeds of a life insurance policy, which raised the following issue. Does the federal interpleader remedy shield a negligent stakeholder from tort liability for its creation of a conflict over entitlement to the interpleaded funds? The idea was that by simply invoking interpleader, a culpable party could perhaps avoid accountability for his or her negligence. Well, as you might imagine, the Ninth Circuit was having none of that. The court held that a claimant may seek to recover all damages directly and proximately caused by the negligent stakeholder's conduct, notwithstanding invocation by the negligent stakeholder of interpleader. Interpleader is simply a procedural device and a remedy. It was never intended to provide a defense or an immunity. Our next case involves an Indian tribe's aboriginal claims in native village of Eyak versus Blank. The Ninth Circuit in Bank considered a challenge by the Alaskan native villages of Eyak, Tatalek, Chenega, Nawalek, and Port Graham, asserting that regulations promulgated by the Secretary of Commerce, which limited certain hunting and fishing in an area of the outer continental shelf, were contrary to non-exclusive Aboriginal hunting and fishing rights they claimed they possess. There are all sorts of interesting legal questions that might be raised and analyzed in this context, but the case was decided against the plaintiffs because after trial, the district court held that given the facts it found, no non-exclusive right to hunt and fish in the outer continental shelf has ever existed for any plaintiff village as a matter of federal Indian law. The plaintiffs appealed on the ground that the facts were sufficient to establish the Aboriginal rights, but the Ninth Circuit in Bank simply disagreed, noting that the plaintiffs did not challenge the underlying factual findings, and those findings were dispositive against the plaintiffs. Next, we have an arbitration case from the Court of Appeal. Applying the United States Supreme Court's decision in AT&T Mobility versus Concepcion, the Fourth District held in Caron versus Mercedes-Benz Financial Services that the Federal Arbitration Act preempts the provision of the Consumers Legal Remedies Act that prohibits class action waivers in arbitration provisions. The case involved an arbitration clause with an anti-class action provision contained in a retail installment sales contract for the purchase of a used car. The Superior Court had struck down the entire arbitration clause based on the anti-waiver provision. But the Fourth District correctly recognized that the anti-waiver provision is preempted. It remanded so the Superior Court could conduct an ordinary unconscionability analysis without the benefit of the statutory anti-waiver provision. Next, double jeopardy. In People versus Daniels, a jury had convicted the defendant of second-degree murder using a deadly weapon. He was sentenced to a prison term of 16 years to life and ordered to pay $3,400 in restitution. The Second District had overturned that conviction on appeal because the trial court failed to give necessary jury instructions on the lesser included offense of involuntary manslaughter. So the defendant was retried, and he was reconvicted on the same charge and again sentenced to 16 years to life in prison. He was again ordered to pay restitution, but this time in the amount of $10,000. Well, the defendant argued on his second appeal that the increased monetary sentence violated double jeopardy, and the people conceded the error. The law is clear that when a defendant successfully appeals a conviction and is retried and reconvicted on the same charge, the constitutional prohibition against double jeopardy precludes imposition of a more severe punishment after the second conviction than was imposed after the first. And that applies to the monetary fine and restitution fine as well. And that's it for today's Kelso Report. Have a great day in the law.